Okay, so today I'm going to present some findings from the process evaluation of the ACT Restorative Justice Scheme for family violence and sexual violence matters, and specifically I'm going to be talking about stakeholder perspectives on barriers to restorative justice for sexual violence. Many restorative justice program formats exist, and you may have heard of a number of them, so victim offender dialogue, circles of support, circle sentencing and conferencing. Restorative justice in the form that I'm going to talk about today has existed as a justice mechanism since the 1970s. It's a conferencing model focused on reparation and dialogue where people who have been affected by a crime can express the impacts, those responsible have an opportunity to take responsibility, and those affected by the crime can develop an accountability plan together. Now, in order to participate, the person who has caused the harm must accept that the harm has occurred and accept some responsibility for it. And through the use of restorative processes, the aim is to achieve restorative outcomes. And the use of restorative justice for gendered violence and sexual violence has been debated for some time, but it's also clear that the criminal justice system fails many victim justice needs. Research on public and victim survivor views show mostly positive attitudes towards the use of restorative justice for sexual violence. Benefits include victim survivor participation and decision-making, the opportunity for victim survivor validation and empowerment, an opportunity for people who've been harmed to confront their perpetrators and hold them accountable in a safe space, and to do this in a supportive environment. However, the key concerns with doing this work are legitimate, and these relate to challenges related to gendered power imbalances, risk of re-victimisation and re-traumatisation, perception about the reprivatisation of violence against women, or that it offers a lesser form of justice to survivors. The views of stakeholders and the evidence of benefits for survivors and their families have previously been examined in the research through interviews with relatively small samples, case studies and small-scale evaluations and pilots, many of which have not been published. So, while restorative justice for sexual assault matters has been operating around the world for decades now, there remains limited empirical data and evaluations, with a recent review identifying only one published peer-reviewed study. Now, the Restorative Justice Unit in the ACT has been operating for decades. Since 2018, the unit has been taking referrals for family, domestic and sexual violence matters at diversion, sentencing and post-sentence. In 2019, the Australian Institute of Criminology was approached by the unit to conduct an evaluation into the program, into phase 3, which is just those matters. The evaluation involves observation of conferences, it involves analysis of survey and administrative data, including reoffending data. It involves interviews with scheme participants, so persons harmed or victim survivors and persons responsible or perpetrators and their supporters. There's also analysis of post-conference surveys completed by participants, and finally, stakeholder interviews, which is what I'm going to focus on today. So between October 2021 and March 2022, we conducted a series of focus groups and interviews to seek the input of key stakeholders who had been involved with the management and delivery of Phase 3, which is the restorative justice scheme as applied to family and domestic violence and sexual violence matters. We spoke to restorative justice practitioners, support service representatives involved with victim survivors and perpetrators, ACT government and criminal justice representatives, including police, corrections staff, and also legal professionals, magistrates, lawyers. Now, as the ACT is a small place, we spoke to stakeholders who have had engagement with restorative justice for sexual violence matters from other jurisdictions, both around Australia and internationally. And this was to contextualise some of the things that we were finding and also to increase the confidentiality of those people that we had interviewed. So the purpose of these interviews was to ask stakeholders about their views on the program, how it was being delivered, any barriers to the delivery, and any outcomes that could be attributed to the program. And now, as you'll see as I go through, many of these barriers that I'm going to talk about today are quite conceptual, and they're related to factors that are bigger than or outside of the control of the ACT unit in particular, but they also impact on the capacity of the unit to reach their full potential in doing this important work. I want to start talking about the findings by saying that there really is broad acceptance of the need for restorative justice as an alternative to reduce the criminal justice system burden, to ensure there is a criminal justice response that prioritises victim survivor needs and interests. And there was acceptance as well among stakeholders that restorative justice was likely to lead to better outcomes for participants than the traditional system. So this stakeholder said, it's not primarily designed for victim justice, it's not a victim justice system, it's a criminal justice system. If your end outcome in half of your contested matters are not guilty, this can mean different things to different people. But to the victim survivor of a sexual assault, that is that I'm not believed. So this stakeholder was talking about the difficulty prosecuting sexual assault through the traditional system and how having a process for people to progress their matters outside of this and try and get some form of positive outcome for victim survivors in particular, it's a very good thing. So the findings from the stakeholder interviews can be kind of grouped into these four broad themes. These are determining eligibility and suitability for referral, perpetrator accountability, ideological or philosophical barriers, and administrative barriers. And all of these barriers, in some way or another, were related to concerns about safety, as I think this will become clear. So, eligibility. Some stakeholders reported confusion or a lack of confidence about which offences were suitable or not suitable for referral to the program. So even where stakeholders did have strong views regarding the suitability of certain sexual offences, there was significant variation across individuals, across organisations, and also individuals working in the same sectors. So the main concerns expressed by victim survivor supporters related to the risk of persons harmed being, the risk of persons harmed being manipulated into participating in the process by persons responsible or perpetrators, and how power and control dynamics would be managed effectively. So this is reflective of what we're seeing in the literature. So some stakeholders were concerned about the risk that perpetrators may use the process to, they might manipulate it to sort of try and restore the relationship with the victim or engage in coercive controlling and gaslighting behaviours. However, there was acknowledgement that an experienced facilitator who understands gender-based violence and trauma-informed practice can do this work well. A number of referring stakeholders across sectors were also able to articulate specific red flags. We call them red flags because they were indicators of unsuitability for referral. These included perpetrators disputing a significant proportion of the reported behaviour or attempting to keep behaviour secret, attitudinal problems among perpetrators, personality factors such as serious narcissistic personality disorders, serious mental health problems, serious alcohol and other drug problems that were being unmanaged. Perpetrators' involvement in organised crime came up as an important one, and also, of course, if the violence was ongoing in the relationship, particularly sexual violence in the context of intimate partner violence, these were considered matters that were just unsuitable. So a stakeholder working in the victim survivor support space talked about how it's hard to conceptualise how a victim can meet with a person who has perpetrated violence against them in a way that doesn't trigger their trauma or leave them open to being re-traumatised. So they said the concerns really lie around safety and how that's managed. It's not just physical safety, but psychological safety. My colleagues are really protective of their clients and super conscious of trauma and the impact of the trauma that clients have experienced. Some law enforcement stakeholders, particularly police, talked about being limited by primarily only being able to refer summary offences. So police can only refer at the diversionary level before court. So they talked about how a significant proportion of sexual assault matters that they deal with are sexual intercourse without consent. But these are ineligible for police referral because they're not a diversionary offence. It's an indictable offence. However, these then don't make it through to being referred because of attrition through the criminal justice process. So they said a large number of their matters that do not progress to court are simply excluded from restorative justice by the fact that they're not progressed to court. Other stakeholders also talked about how there was a low rate of guilty pleas for sexual assault matters, and this also impacts on referrals because then they are ineligible. So this stakeholder said, a good proportion of child sex offenders that appear in front of us are deniers. So they would simply not bother referring someone like that to RJ. Managing power dynamics, again, was a key concern of stakeholders and something that was really front of mind for practitioners engaging with the program. So the practitioners that we spoke to spend a significant amount of time conducting ongoing risk assessment, investigating power dynamics, gender roles and balance within the relationship, if one was present, and looking for evidence of coercion. Having an in-depth understanding of the history of harm in the relationship was talked about as very important for understanding the subtle ways that abuse might present and being able to recognise that in the moment. So having a co-convener model where there are two conveners in the conference rather than one was talked about as quite helpful in this sense, because you have two people who are watching what's going on and able to identify these more subtle dynamics as they're going on. Another approach to managing power dynamics was to try and match the quality of supporters there for both the victim and offender in the conference itself. Restorative justice stakeholders also referred to a number of key indicators that they use as evidence of a willingness to acknowledge wrongdoing and accountability, I guess, so evidence of potential to benefit among perpetrators. And these were a person's willingness to hear the impact of that their behaviour has had on others, a person's openness to having their behaviour heard by their broader community of care, such as their family members and their close friends, and a person's willingness to acknowledge a history or pattern of behaviour where there was one. So this stakeholder said, there is a different language that is used when somebody is taking full responsibility than when they're just doing a shallow approach. It might be that they're not turning up to appointments, or they didn't turn up to see their specialist or professional supporter. So it's using those kind of indicators to piece together more than just what someone might be saying. A few stakeholders reported scepticism around the motivation of offenders for participating, saying that they just do it to look good, tick a box, get a reduced sentence, rather than being genuinely motivated to repair the harm. And this is, a key concern also that's in the literature as well. Interestingly, other stakeholders advise that the initial motivations of people responsible for participating, these aren't necessarily a clear indicator of their potential to participate meaningfully in the process, or for their potential to benefit, or for the potential of the person harmed, importantly, to benefit from the process. So these stakeholders describe the importance of understanding where a perpetrator or person responsible is at in their accountability journey, recognising that someone's level of accountability and their motivations for wanting to participate can change throughout the process, and should change throughout the process, ideally, as a result of the process. Also, as a victim-centred program, some stakeholders thought that being too prescriptive around this was limiting opportunities for people to participate and benefit. So this is captured in this quote from a legal professional who said, "I've seen that happen through defence work, where the person has said, yeah, we just sort of signed up because we thought it would look good, but in fact, it was actually quite good to meet with the person and I got something out of it. I would say it would be foolish to refuse someone just because they're trying to get a benefit. Every person who's going before a court and is about to be sentenced is trying to do everything that will look good for them. Another repeated theme was that restorative justice was viewed by some referring stakeholders as a soft option and not suitable for serious violent offenders or serious sexual offenders. Also, there was a perception that restorative justice was not suitable for some types of sexual offences, particularly stranger rape or sexual violence occurring in the context of intimate partner violence. This was seen as too unsafe. And there was a perception among some stakeholders that some sexual offenders would just never be appropriate for referral, sort of tying back into that quote from before, nor were people who had been referred before and then had reoffended. So this stakeholder said, it's demonstrated in this quote where they were talking about RJ in the context of repeat offenders, and they said if it worked, they wouldn't be recidivist. Several stakeholders reflected on the legacy of long advocacy for sexual assault and domestic and family violence matters to be taken seriously by law enforcement agencies and the fear about reprivatisation of violence against women and competition for funding across already seriously stretched community services. So this again is in line with what we see in the research. However, all stakeholders involved in supporting victim survivors really recognise the importance of having RJ as an alternate or complementary process and pathway to the traditional system as a victim-centred response to sexual violence. So one stakeholder I spoke to who had been working as a survivor, supporter and advocate for decades, they talked about how people can really gain strength for themselves through meeting with a person who has harmed them and confronting them in a safe space. However, they felt that it was safest to be employed as an educative tool for those for whom there was less evidence of an intentionality to harm. So they said, it's a space that can really teach people who don't understand the word consent. There is a difference between somebody not understanding what the word consent is to a person who is a sexual predator. You learn those kind of differences working in that space. The final theme I'll talk about from the interviews is the administrative barriers, particularly the delay from when a matter is referred to when a convener is able to take it on. Now, from a practitioner perspective, it's so important that this work is done in the time that it needs. It takes time to do this work safely, and you need to work with people where they're at. So people might be participating in treatment and getting to a place where they're not quite there yet, but they will be soon. But from a policing perspective, they might not, the risk associated with that delay is something they sometimes don't want to take on. The difficulty accessing treatment programs for harmful sexual behaviours in the ACT was reported to be a significant service gap with limited options outside of corrections, and some people being referred to programs in other states as well as being linked in with other non-specialist services and of course engaging in one-on-one treatment. So this stakeholder said, we do rely on those community agencies, but again, they have these huge and long wait lists. So as we're preparing participants, there might be a 10-week wait list. So some of the obstacles that we do have is that keeping momentum and that motivation. So when there's delays with services, such as, community services, we can lose people because we lose that momentum with those wait lists. So this is something that is not unique to the RJU, it's something that all community services have, as you will know. Also, complex legislation and paperwork. Law enforcement stakeholders talked about unfamiliarity with referral processes, being more used to doing court referrals than RJ referrals, but they really recognised that their own processes needed streamlining and that they could be referring more matters, and many agencies were in the process of doing this at the time that we interviewed them. One lawyer I spoke to talked about how the indefinite delays associated with participating in RJ was a barrier for some of their clients, as their matter sometimes needed to be put on hold until the process was finalised, and you don't always know how long it's going to take. And they talked about how there were other ways to show remorse, like a statement of responsibility. So they said there's a number of other routes to make the exact same point that would take less time. However, I think generally it's understood that that's probably the best way to make the point is through restorative justice. It's always easy to make this self-serving statement, yeah, I'm sorry, but when you actually have to look at the victim and actually do it, you can really weed out the people who are not genuinely trying to do that. So they acknowledge that delays shouldn't be a deterrent for everyone wanting to make amends, and that the best RJ was really the best way to genuinely take responsibility for behaviour. So I've spoken about barriers to referral today, but I just want to re-emphasise that there is overall support for this program. Stakeholders really recognise the importance of having this victim-centred process available for survivors of sexual violence. The preparation period from when a matter is accepted to when in the lead up to the conference is really critical for success in terms of these matters and RJ. And while stakeholders report safety concerns and how these lead to risk aversion in terms of referrals, more information sharing about the significant risk assessment and risk management processes that are conducted by the RJU in the lead up and on an ongoing basis may help alleviate some of these concerns. Our findings do reflect the literature that those with more engagement with the program do report more positively about it. Structural and administrative barriers, these require further investment and cooperation between stakeholders, not just on the RJU to address. And the lack of programs for people using harmful sexual behaviours in the ACTs are clearly an area that needs attention. The bigger picture ideological barriers around the suitability of restorative justice for sexual assault, these are harder to change in the short term, of course, but hopefully there is a shift over the longer term as the program, if the program continues to provide benefits and meet the justice needs of victim survivors of sexual assault. And before I finish, I want to acknowledge my colleague, Dr. Hayley Boxall, who isn't here today, but was really foundational in getting this work off the ground and has been my very close collaborator on this project, and also the support of Cameron Long, who sat in on many of these interviews. Lastly, and most importantly, I need to recognise the amazing people at the unit, Sweet Leanne Siat, Richard Denning, Amanda O'Neill, and others who have been so generous with their time and support and open in working together on this valuation. Thank you.